Please, Lordship. Lordship, I beg to mention the item number 10, Lordship.
10.
10, Lordship.
Ah.
This matter may be adjourned for 2 weeks, Lordship.
Why?
Lordship, we have to file our affidavit, Lordship. I have
Yeah.
taken the consent of the other side.
Yes, Mr. Devi.
Yes, man, I am for the petitioner. I have no objection, man.
Item 10.
There is a entry model related to
Adjourned for 2 weeks at the request of the Governor
Lordship.
Arunachal Pradesh, Mr. Arun Chandra. Matter be listed after 2 weeks. On 21st April,
Yes.
interim order passed earlier, will continue the next day.
Much obliged.
Obliged.
Yeah, please. My lord, I beg to mention for withdrawal, my lord. It may be listed on 25/3/2025.
On
Tuesday, right?
Tuesday, not on Monday.
No Monday. Tuesday.
Tuesday, all right. Tuesday.
May I please, Your Lordship? Your Lordship, I beg to mention item number 4, Your Lordship. Matter has become infructuous.
Item,
Item 4.
item 4.
Yes, Your
I
Lordship.
am for the contender in this matter. Sir, this order of the single bench we have set aside, Lord.
Set aside
But
by division
division
bench.
bench.
Division bench.
It is submitted by counsel to the petitioner that the contempt petition was filed alleging willful disobedience of the directions contained in the order dated Mr. Party, WBC so and so. MS
N. Mohanta.
N. Monroe and Mr.
NK Sharma, Lord.
N. K. Sharma. Counsel appearing for the respective parties submit that the directions, the order of the learned single judge has been interfered with and set aside by in
By
appeal.
the writ appeal number 107/2020.
Read appeal number 107/25
2023.
2023. Accordingly, the petitioner does not wish to press the contempt any further. Taking into consideration the submit contempt petition stands closed.
Deeply obliged, Lord.
Deeply obliged.
This is the order.
Lordship, I beg to mention for listing of a writ petition. The matter pertains to termination of the petitioner without any show cause notice.
Without
Any show cause notice.
matter pertains to
Termination of the.
termination.
Yes.
It's a fresh matter, old matter,
No, Lordship, it's a pending matter.
pending matter. When
Yes.
was it last listed?
Last listed on 7th of March.
2025.
Yes, Lordship. It was supposed to be listed after 1 week.
Let it come on 4th of April.
Lordship.
Yeah.
Deeply.
May I please, Your Lordship? Lordship, I beg to mention item number 20. Lordship, pleadings are already completed.
Then you
Lordship.
wait. You wait for the matter to be called.
May it please, Lordship? Lordship, I beg to mention item number 5.
Yes.
Lordship, some of the containers are retired and some are transferred from their post, Lordship. So we need some more time to implement new parties.
Your name?
J. Besborwa.
MSJ Besborwa, learned counsel for the petitioner, submit that some of the respondents have already debited their respective offices, and as such, the present incumbents are required to be brought on record accordingly. Please for 3 weeks' time, take step, complete the present incumbents in those posts. Prayer made, not objected to by counsel for the respondent accordingly. This after 4 weeks.
Obliged.
May I please, my lord? Notice an application under section 11(5), my lord, for appointment of an arbitrator. My lord, the agreement is at page 42.
Yes.
No, page 42 was the contract agreement executed by the Border Road Organization, my lord, between the petitioner and the respondents. My lord, page 44 is the contract agreement. My lord, pursuant to this contract agreement, my lord, the contractor, my lord, failed to perform the contract, and consequently the contract was terminated. My lord, Paragraph 3, my lord, I stated.
Where is the termination order?
My lord, termination order, not annexed, my lord. Paragraph 3, we have made a statement. Paragraph 3, my lord, the
Where is the arbitration clause?
arbitration clause, my lord, is at page 51. Clause 17, my
Third,
lord, clause
Mr.
17.
Ray, certain account. You are the union.
Yes, my lord.
Why are you filing?
My lord, for risk and cost, my lord, because the contractor has failed to perform the work and thereafter the remaining work has to be executed through other contractor, due to which the department has incurred cost, my lord.
No, no. After termination, what happened?
After termination, my lord, we gave the work, remaining work to the other contractor
Ah.
and then gave notice to the contractor whose contract was terminated, asking for recovery of risk and cost expenses incurred by the department.
Then
Then, my lord, the party didn't respond. Therefore,
you pursue it. Why you filing an arbitration?
page 115, my lord, we'll see. Page 115, we have represented several times to the contractor to pay the risk and cost. He did not
You have
respond.
other means of recovery. Go and recover it.
It's a dispute, my lord, so we are coming before for an arbitration. 11.5, my lord, page 115, my lord, annexure 3 was the notice invoking arbitration clause. Paragraph 2,
Where is that notice?
page 115, my lord,
115.
notice invoking arbitration clause.
How is the risk and cost to be recovered as per the agreement? What are the terms in terms of the agreement? Where is the clause for termination?
My lord. My lord, page 99, my lord, page 99, my lord, it is part of the general conditions of contract, which was mentioned, my lord, in the agreement which I have referred. Page 99, clause 28. Cancellation of contract in part or in full for contractor's default.
So come to page 100, second last paragraph. Your contractor's performance security retention money are forfeited.
My lord.
So has it been forfeited? Material lying confiscated.
This instruction what I have to take, my lord, because we are not able to recover the amount even after.
You are not able to recover this performance security retention money
Yes, my lord.
is supposed to be available with you. If
Yes.
you have released it, you have released it.
No, even after that, this amount is due. Even after,
Then
my
you
lord,
should have been careful about deducting whatever amount is there before releasing the final bill.
sometimes, my lord, that amount is not sufficient for recovery.
You give a detail. Have you given the details of the amount recovered and the amount recoverable?
No, my lord.
Then bring it on record.
My lord.
Mr. A. Gupta, submit that is arbitration by the Union of India. praying for appointment of an arbitrator. To resolve the disputes between the petitioner and the respondent. So the respondent was awarded a contract for window page number 2. Since the contractor was unable to complete the contract, and since the contractor could not start the work despite various diligence notices, no response was received from the contractor, and the contract was cancelled in terms of clause 28 by communication dated 17th August 2019. So the balance work / the work left to be completed by the petitioner was carried out by awarding the contract to another contractor at the risk and cost of the respondent. So, according to the petitioner, certain amounts are due from the respondent, which they have failed to repay in terms of the contract and the agreement signed by the respondent. Mr. Gupta, however, not able to place before the court the amount receivable, stated to be receivable by the petitioner, and the amount which were already paid the respondent in terms of the contract. These particular, Mr. Gupta submits that these particular he can submit upon completing his instruction on the same. So he takes each time. Please again, at the request made, please again on after 2.
As per the Lavazima Court order dated Lordship 14 to 25, the service of notice upon the responsible 16 has been completed. So may I pray the matter will listed for a admission hearing, and in the meantime the government has filed their affidavit. So we are supposed to file our reply. on it.
H3 appears for the petitioner,
Petitioner.
Mr. T.P. Sutia,
I am for 3 and 4, my lord.
respondent 3 and 4. Mr. A1 for
Respond number 2.
3, 4 and 5.
I'm for 2.
Mr. Sutia for
3, 4 and 5, my lord.
3, 4,
1 and 2 negi, DDA, 1 and
Who's for 1 and 2?
1 and 2 I am appearing on.
Mr.
EAD.
A1 appears for
Pending on.
Okay, for the Lavazima Court order
14.
dated 14/2/2025. Service on respondent 6 to 8 have been completed. Accordingly, if the service on all respondents are complete, matter be listed for admission in the month of May. On a date to be fixed by the registrar.
There is a interim order operating
Interim order,
passed on 25/2020.
interim order is any, we continue.
Obligatory.
May
Yes.
it please your lordship. Lordship, petitioner is the second wife of the deceased husband.
Why is it for orders?
Orders, lordship,
Some
already,
additional affidavit was to be filed.
additional affidavit I have not filed, but I have that Kabilnama.
Right, there is an order of the court.
Yes, lordship, I'll file it. 1 week time, within 1 week I'll.
Fine.
Yes, lord.
In any case, second, you're the second wife.
Yes, lordship.
First wife is still alive
Yes, lordship.
and she's receiving pension.
Yes, she is receiving pension. And she is also here respondent, lordship, but
Who's
it is-
appearing on our behalf?
PNRD council was also there earlier. Mr.
You
Dotto.
you bring it on record.
Yes, Lordship, I'll bring in, 1 week time is enough for me to bring that on the top.
MSD votes for the petition. Renews their prayer for a week's time for filing the cabin number. In terms of the earlier order of its court, dated 28/7/2023. So let this cabin number be placed on record by way of an affidavit within 1 week as briefed.
Yes, Lordship, I humbly pray for fixing the date. If within that, maybe Monday or Tuesday only I'll file it.
Let the matter be listed again on 4th April.
Yes, Lordship. Deeply obliged.
May I please? Lordship, kindly ask for matter time being, Lordship. A talukdar is election another code, Lordship. Time being, Lord. Please
Time
kindly-
being,
Time being, Lordship.
what is the matter about?
The matter is a compensate appointment, Lordship. The petitioner father was working as the second assistant in the Office of Executive Engineer, Kachar.
I am appearing for F1 number 1, Your Lordship. Lordship, my affidavit is ready, Your Lordship, but since the incumbent has no more in that post and the name of the division is also renamed, Your Lordship, we could not file it, Your Lordship. In fact, the order is already complied, Your Lordship. The DLC already recommend her name, Your Lordship. The or direction of this honorable court to place the matter second time before the DLC.
Where is the direction of the court?
That's in Annexure 1.
Page number 11, the operative, operative,
Para number 4, Lordship.
para 4, Your Lordship. I have the minutes of the DLC. Your Lordship.
Yeah, where is the order?
Lordship, I have the minutes, Your Lordship. May I please? I have marked it.
What is her name?
Orishi Dhar.
It's already done. Have you seen the order?
No, I have not found.
No, Lordship. I have not
Oh, it-
copy.
It's already done. What is this minutes?
Yes, the minutes of the
Now I
DLC.
will-
The front page.
So we are closing it.
Yes, sir.
Heard. Done and done. But this contempt petition, it's by a petitioner alleging willful disobedience of the directions contained in the order dated 19/9/2020 passed in WPC number 6117 of 2020. So the in the writ petition filed with the petitioner, the the writ petition filed with the petitioner came with a truth of with in terms of the state directing the respondent
Already complete.
to place the application of the petitioner for compassionate appointment before the DLC, Kachar district, and to take a decision on the merit of such an application without rejecting it on the ground that it was submitted 3 months beyond the date of death of the employee concerned. Yeah. Today, when the matter is called up, counsel appearing for the
Lordship,
PHE,
Lordship, and for respond number 2, Lordship, we have filed our affidavit also.
PHE has placed before the court the minutes of the meeting of the DLC held on 6/2/2023.
Yes, your lordship. Yes, yes.
That the case of the petitioner was placed again before the DLC and the same was considered and the petitioner case was recommended for appointment with the vacant post of.
Lordship,
Give us a copy of that minute.
wait, your lordship.
Nine.
And the DLC has decided to recommend the claim for consideration for appointment again admissible vacant post of action assistant in compliance with the directions of the copy of the minute placed before the court is kept on the case court. In view of the decision taken by the DLC in terms of the directions contained in the order dated so and so passed in WPC so and so, it appears that the directions have been duly complied with. Since the directions have been complied with, taking into consideration, also taking into consideration counsel for the parties, this contempt petition stands closed, notices are recalled. MS
Hard.
A Talukdar.
A. Talukdar appears for
Respond number 2, Lordship.
respondent number submits that an affidavit has also been filed. MS R. Deka
For
appears
respond number
for
1.
respondent
1, your lordship.
petition according to stands closed in terms of
Oblige, your lordship.
in terms of the law.
Lordship is in contempt case. And we have taken all the necessary steps.
Pursuant to the order dated 3/10/2024, permitting the petitioner counsel to take fresh steps, it is submitted by the counsel, the petitioner, that steps have been taken. Stop. Accordingly, await service report on the respondent. How many respondents? Service report of the respondent. It's after 4 weeks.
I highly obliged.
May I please, Your Lordship? Your Lordship, the matter may come infructuous here. Sir. The matter may be closed.
It is submitted by the council to the petitioner. And
It-
his writ
it-
petition has become
it-
infructuous, and therefore the petitioner does not wish to press the petition any further. Mr. Renu Upadhyay appears for the
Irrigation Department.
irrigation department. Accordingly, writ petition stands closed as infructuous. Imprimatur detainee stand vacated, and pending ayes are also written.
Obliged.
Lordship, may kindly pass over this matter for time being. My senior is on Lakes on court number 1.
Your Lordship, I am appearing on behalf of Mr. S.S. Roy, who is appearing for the response number 2. Order is complied, Lordship. Direction is given to constitute a review medical board, and that was constituted in terms of the order dated 15 December 2023, and he is found to be unfit. May I provide copy of the for response number 2. Order. Comply probably with more. Appeal review board shall examine the case.
Where is that review?
Lordship, the instruction, paragraph 2, Lordship, it is stated. May I read, Lordship?
Yes.
In compliance with the judgment dated 15 December 2023, passed in petition number so-and-so, review medical board in respect of the petitioner was conducted with effect from 9th November 24 to 15 November 24 at CRPF Composite Hospital, Guwahati, wherein the petitioner was again found unfit. So in this connection, copy so-and-so is given. And the board proceeding is also given.
Have you shown her a copy?
Nothing, take another because otherwise also SS Roy is today out of session. So in his
What
presence,
is the point in giving it?
you can provide a copy. Lord.
All right, we'll call it up at the end of the list. End of list. Inform your senior. If he's available, we'll pass orders in his presence. Otherwise, you remain present. End of the list. And Mr. Sharma, you also remain. Sorry.
We were required to, my lord, take that from the private respondent. Because using number, we don't have their addresses also, and alternative service was
Paper
thought to be
publication.
affected. But then these petitioners, my lord, they are unemployed. They're not being able to afford, my lord, the newspaper publication.
Then?
So I take some time to take instructions, my lord. Maybe probably they will not be able to pursue.
What is this issue about?
Issue was about, my lord, awarding of marks in Viva, my lord. We said that the proportion has gone beyond the standard prescription of 12.2% that is there in the APSC. In this case, my lord, 28% marks were, my lord, ascribed to the Viva.
Financial Management Officer.
My lord.
Who's for the APS?
My lord.
You take your instructions then.
No.
Because these will the respondents will have to be notified.
Because they are already selected.
Mr. B. Patak, would like to take some instructions from the petitioner. He prayed for 3 weeks' time. APHC represented by
B. Sharma.
Council. Already. Anyone else? APHC.
11.
List after 3.
Obliged.
Lordship, this matter may be time being, Lordship, Mr. Dasgupta, because it's code number 1, Lordship. Time being. Let it be on some other day, they will then.
We'll call up again at the end of the list.
I have some direction.
All right. Who's filed the IA?
I filed that. Well, I filed the IA because it happened like this, my lord. The petition is filed against an order of recovery, challenging the same recovery order. 10 petitions were filed, and 4 were disposed of, allowing the petition, giving us the liberty to initiate the department proceeding. That liberty we are seeking in this. Only, my lord, this same
You
order.
want to file objections here in the IA?
No, Lordship, I have no knowledge, Lord.
Then we'll have it.
On Monday, Tuesday, any day, because
26th,
26. Problem.
the joint request letter has been heard again on 26th of and appears for the petitioner on call. And it appeared for the petitioner on call. And the matter was discussed again earlier on 12/3/2025. Only for the end of justice. Matter we called up again after 4 weeks.
May I please, your Lord? You know, this is relating to Samway Samiti Secretary, post of Secretary of Samway Samiti. He has been terminated from that's why this case. What happened, my lord, in this case? He was initially appointed as the Assistant Secretary. Thereafter, he was promoted to the post of IC Secretary. And for a long time he was serving. Meanwhile, my lord, so what happened? The Deputy Commissioner sent the offense report to the CGM Kamrur Metro. Right. CGM has taken cognizance. Someone was issued to the petitioner. So that case is continuing. By this time, the less number of, not majority members of the director of the Samiti, they have taken resolution to terminate it. So, my lord, ultimately the ERCS, he has terminated. Before termination, my lord, what happened? 9 number of directors, they submitted application not to approve his termination. Resolution adopted by the other members should not be approved, termination by the ERCS, but ERCS has terminated, approved. ERCS has given the approval. That has been, my lord, done actually at the behest of the minister concerned. It's a political action, my lord. Record is clear with reference to the minister's interference. So, my lord, it is absolutely political. action, not executive. So, my lord, we have submitted IO for uh, uh, stay of that
But,
approval to the
but as per the last order,
My lord,
man.
private
4,
respondent awaited.
411,
Man.
you are permitted to take steps on
Man.
the respondent.
We took steps, my lord.
You are
The
appearing?
official respondents they have
My lord,
taken. Extra copy has been given.
On private respondent is awaited, my lord.
Yes,
It's
private
awaited.
respondent.
Private respondent is
Yeah,
awaited.
it's-
Court service. Service on private respondent is awaited.
You are appearing for
For
whom?
SK Talukdar,
আমি
standing
both
counsel.
violation, na, registered and penal. We took steps, my lord, both way, registered and general
But the
also.
office note says that no steps have been
Awaited.
received. Office note says steps have not been received.
Oh.
Meaning that the particulars for the steps to be taken to the office have not been received from you. This is the office note. You have taken steps.
We have taken steps, my lord, both way, by registered post as well as general.
As per office note 10/10/25, it is seen that steps as directed by the earlier order. Its court dated 4/11/24 has not been received in this section. Mr. J. Buddha, counsel for the petitioner on the other hand submits that steps have been taken in respect of all the respondents, including the private respondent.
Yes.
By registered
By
post
registered
and
as well as
usual court.
yes.
So, registry is therefore directed to verify and make necessary endorsement with regard to the submission that the steps have been taken by the Mr. Your name?
K.A. Sodial. K.A. Sodial.
K.S.
So K.A. Sodial.
K.S.
K.A. Sodial.
Sotia. K.A. Sotial appears on behalf of Mr. S.K. Talukdar for the cooperative part. This matter again after 2 weeks. What about the IA?
My lord,
The same order,
stay of that approval.
the same endorsement, no steps taken.
My,
So let the
my
registry verify
lord.
for both in IA and the writ petition. And to be listed after 2 weeks.
That's all.
Like this IA, petitioner wants to incorporate certain documents which were not available to him earlier, so that this can be taken up along with the writ petition. So I pray for that it may be allowed. And I will.
So if you are seeking to bring these documents on record, the respondents will have to be given an opportunity to rebut.
These are official documents, Milord.
What do you say?
Previously, I could not
My
find it.
senior friends will have
Now-
to file an impleadment petition in that case, Lord.
No.
No,
What impediment?
If it
They are
is a
seeking-
Sorry.
I will file an additional affidavit incorporating those documents if it is allowed.
So far as payer is concerned, my lord, payment of pension, my lord, pension department is not made a part.
Hmm?
Payer is to pay pension, my lord. So pension department is not made a part.
It is the
I am appealing for response for one. Pension
government was of his party. So department, unless
Another thing, Lordship, in this case, Lordship, the petitioners are from different districts, Lordship. Under different, Lordship, 1, 2, 3, 4, 5 executive engineers, Lordship. All are clubbed together, Lord. This is the problem, Lordship.
So who is to release the pension? Accountant General.
Lordship, they have to first regularize, Lordship. They are not regularized. Until and unless they regularize, they this is a master of
only
law.
for that, Milord, this application is here.
Okay. So you bring it by way of an additional affidavit. Will allow the IA.
My lord, That's only I want.
We'll allow the IA, let him bring it on additional affidavit,
Additional affidavit.
Lordship,
in the IA, 685. The IA is filed by the petitioner. Bring on record certain additional document which the petitioner submits has hearing, which the petitioner submits will have hearing in deciding the writ petition WPC 863 of 2023 filed with the writ. This prayer, considering the prayer made, this court is of the view that this IA can be allowed, permitting the writ petitioner to bring these additional documents by way of additional affidavit in WPC number 7. Any such affidavit that may be filed, the respondent will have liberty to respond to the same additional affidavit.
Lord.
In terms of the above, the IA stands allowed and so on. Let the additional affidavit be filed within 3 weeks.
1 week.
3 weeks. 3 weeks. And the matter in petition be listed thereafter. IA stands allowed to dispose.
Acknowledgement.
Mr. Upadhyay and Mr. Sukhia and Mr. Ali appears for the respondent, respective respondent.
Lord.
May I please, my lord? I am on behalf of Mr. DC Bora, my lord. But in this case, my lord, instruction has been received. Parawat's comment has been received, my lord. There is some clarification, my lord. We already letter, my lord. Sometime may given, my lord.
Yes, Mr. Sharma. Mr. Your name?
KM Hassan.
KM
Hassan.
Hassan has entered appearance on behalf of Mr. DC Bora and submits that the instructions have been received and they would like to file the necessary affidavit upon receipt of certain clarification, further clarification from the respondent. Prayer is made for adjournment of the matter for 3 weeks. Mr. J. Sharma, the counsel for the petitioner, does not object to the prayer. Please take order.
Lordship, I am appearing for number 10 and 11, your Lordship. Lordship, I have received instruction. Some time may be granted to file my counter, my lord.
Yes.
Okay.
The submission is made on behalf of the counsel appearing to respondent 10 and 11.
10 and 11, Lordship.
And the instructions have been received, we like to file an affidavit. So prayer made is not objected to by the counsel for the petitioner. Mr. Sharma appears for
Number 418.
respondent number 4, Mr. Property Board.
2.
Respondent number 2. Mr. Rongang for respondent 678. Mr. Cholia for respondent number 3. Let the matter be listed again after 3 weeks.
But that may be case of exceptional matter.
My name may be reflect, my lord. Kedas, Lordship.
Matter be listed again on 23rd April. Names of all councils, including Mr. Kedas, be reflected in posted by the rate.
Lord, we have received Parawat's cover would file affidavit.
Okay. As far as the preferential appointment matter under the provision of Rule 3, my lord, they could to get the preference in the
examination if they are appeared in this. The petitioners appeared in several advertisement examination, but they are every time deprived. But in the last occasion, my lord, in the year 2023 and 24, my lord, examination, they appeared for SLRGG, where 13,300 posts are lying vacant, my lord. So, my lord, petitioner only humble prayer to get the preference. So, as and when selection is made.
Preference because they are descendants of martyrs.
My lord, annexure 1 series is there, my lord, is page 23 to 28, my lord. The certificate is there.
Who prefers? Wait, wait. Oh, under APS, no, Rule 99. This prefers to me.
Direction,
No direction over
Where are the certificates?
my lord, annexure 1 series, my lord. Page number 23 and 28. Disablement certificate. Advertisement is annexure 3 series, my lord. Page number 47 to 50.
This is when a Ketana, now so many repetitions were disposed of. There was no direction. Only says, my lord, when he will appear in the selection process, if he comes at par with someone, that suffice will come, and nothing.
No, what is your prayer here?
My lord, one only when in persons of advertisement, two advertisement in the prayer is shown, my lord. That should be in purpose of the advertisement. They should get the preference. In the I pray in the prayer, my lord. Advertisement, my lord, number 1 3 oblique.
So why are you apprehending that you will not be given preference?
My lord, earlier time, my lord, in several advertisement I was contested. My lord, every time I was deprived. Similarly, candidates, my lord, annexure, my lord, 8 appointment letter, 2 appointment letter was annexed. They were also contested with the petitioner. Their serial number was, my lord, 4 and 17, and our serial number is, my lord, 2 and 45. And they were appointed, but we are not appointed. And every time, man, we are deprived. That is why I filed this interpretation. Only prayer for direction to give the preference, as and when election was prepared.
This preference is different. We preference only when at
In a
par.
direct
Two person when
If the provision
that is not our grievance, but we should get also the preference in the appointment.
what preference?
But this is have you applied for
My
the
lord,
advertisement?
My lord, my lord.
What is the state?
This
the selection
representation is
process?
also page 54 to 50, 62.
What is the stage of the selection process?
Application is there, my lord. My lord, dear admit card is there, my lord. Page number 89 to 90.
Where is the advertisement?
2023.
2 series, my lord. Sorry, 3 series, my lord. Page 47 to 53. Vacancy list also enclosed as annexure number 31, page 114 to 116. Vacancy position is there.
Interview when no? So interview to when है?
Interview 2023
Selection तो पहले गो. Selection तो पहले गो.
But we will manage to we file this petition.
कितना बना ना selection पहले गो तो. होई गो तो. कोई नहीं दिया फोटो को. Selection तो पहले वापस तो.
My lord, that selection also published in the first week of this March 2025. But in this time also petition are deprived, not selected.
Number compare করতে হবে.
don't understand is why are you apprehending that you will not be given the benefit?
That is why
If the selection process is in progress, as and when the situation comes for you to apply this relaxation, it be applied. If it is not applied, then you come before the court. Why do you want a direction beforehand?
My lord, we are not, we are, each and every time we are deprived from the selection.
Each and every time did you come before the court earlier?
That is why, on.
Did you come before the court earlier?
On apprehension file this.
No, apprehension is not a ground.
And already, my lord, selection list already published in the first week of the.
Is your name there or not?
But our petitioner name is not there.
Where is that selection list?
Selection list, my lord, vacancy position is there, but selection list not.
Then you have to challenge the selection list.
And now we have to file it, another petition.
Then
Observation.
Then this
will be-
petition has become infructuous.
My lord, this petition only filed for this apprehension.
No, that apprehension is no longer there when the selection is there.
My lord. But before this publication of selection list, file this incentive petition.
You may have, but now the selection list is out. You are not selected.
My
If
lord,
you want to argue,
my lord, I may be allowed to give the observation to file this another petition.
all right,
challenging
Mr.
the
V.
selection.
Islam, learned counsel for the petitioner, and Mr. T.C. Surya appears for the
Not present.
respondent.
You are not pressing.
Number 1, 2,
My lord,
1, 2, 3, 4.
Yeah.
And
I am appearing on behalf of Mr. P. Raskot, standing until 4% defendant. My lord, I am for respondent number 11 and 12.
Mr. So-and-so appears for 11 and 12. Who's for agriculture?
Agriculture is not appearing.
You are appearing for agriculture?
No, my lord.
No.
M. Kotoki, M. Kotoki is appearing normally. Oh, no, Chaudhary, no? D. Chaudhary.
Huh?
B. Chaudhary is appearing
D.
for
Chaudhary for agriculture division. Right. This writ petition is filed by the petitioner expressing apprehension that in terms of the
Assam Public Service.
some public
Preferential
service within
appointment
bracket,
route.
preferential appointment bracket close
Nin-
rules
1999.
1999. The benefit which the petitioners are entitled to for getting preferential treatment for being the descendants of victims who suffered, who suffered injuries or were killed during the Assam agitation. Will not be, may not be considered, may not be conferred on the petitioners. Petitioners had applied in response to the, where is the advertisement?
Advertisement is annexure 3 series, my lord. Page 47 to 53.
How many advertisements?
Two numbers of advertisement there.
Where is the first advertisement?
First advertisement is
25/3/2022.
Advertisement dated 25/3/2022
Next
and
30/10/2023.
30/10/2023
Next 27/10/2023.
and
3 advertisements.
27/10/2023. So it is submitted that in all these advertisements, the benefit of relaxation conferred under the said rules of 1999 was required to be conferred. So, the counsel for the petitioner submits that the petitioners apprehend that their cases may not be given due consideration under the said rules, and accordingly, present writ petition by para. Mr. Islam, however, fairly submits that during the pendency of the writ petition and pursuant to the selection process undertaken in terms of the advertisement dated for enforcement, the select lists have been published and the names of the petitioners are not reflected in the said select list. Therefore, submits that he would like to challenge the select list as well. and brave leave of the court to file appropriate proceedings before this court in challenge the said selection. So, this submission is not objected to, is not disputed by the counsel for the respondent. Accordingly, in view of the submissions made by the counsel for the petitioner that the select lists have already been published and the petitioners were not found to be selected in the same election process, the petitioners are permitted to take necessary steps to question the selection process if they are so advised. So, however, for the present, since the select list have been stated to have been published, there is no further cause to be pursued in the present writ petition, and the same is therefore writ petition dismissed on the petition made above with liberty. Interim orders, if any, is vacated.
Always.
Yes, Mr. Sonia.
May I please, Lord, my lord, last time, my lord, this is time, my lord, for taking instruction, my lord, matter relates to my lord.
My lord, I'm on behalf of DC Bora, my lord. He is out of-
Louder. Can you speak a little loud?
My lord,
Yes.
my lord, I'm on behalf of DC Bora, my lord. He is out of station, my lord, due to his medical treatment, my lord.
My lord, this can be disposed of also, my lord,
Yes.
because, my lord, I have been, my lord, dismissed from service with 4 years imprisonment, my lord. So accordingly, there is a provision for appeal, departmental appeal, my lord, under 117 of the BSF Act, my lord. So I made an appeal, but they have not disposed of my,
Oh, they have not disposed of.
this of my appeal, so that I can take the other remedy, my lord.
All right.
So only thing is that, my lord, the same time petition, my lord, coordinate will dispose of this, my lord, directing to my lord, consider the appeal representation, my lord, within a period of, my lord, then some document has been not provided, but that may be, my lord, direct to provide, my lord.
They have already filed an appeal.
No, my lord, because of limitation, I have made a categorical statement, my lord, because of limitation, without those documents, I filed the appeal, my lord. But in case of, my
So
lord,
then you file an application before the appellate authority.
I made, my lord, that is, I have annexed, my lord. I have made, my lord, that
So
is,
see,
my lord.
it's one thing to say that, all right, where is their application?
Application 99/2024, my lord, last page, last annex 8, my lord.
9/9/2024.
Prior to that also I have made, no, last one is 99/2024.
This is the appellate authority. No,
My lord, he is the authority who can provide the documents, my lord.
no, but not the appellate authority.
Appellate authority, he is looking the appeal also, my lord, that officer, my lord, the chief law officer
He is the appellate authority.
of the authority, my lord. He is on behalf of
Where is your
Director General of BSF, he is looking
Where
after,
is
my lord.
your appeal?
Appeal is, my lord, page 36, annex 7.
No, it is addressed to somebody else, different officer, DIG. Okay. He is the CLO,
My lord.
chief
Chief
CLO.
law officer, same person, my lord. Only by designation is a deputy inspector general, my lord.
All right, then we are closing it.
Right.
Mr. M. Soronia for the petitioner, Mr.
KM
Hassan.
Hassan. KM Hassan.
KM Hassan, appearing on behalf of Mr. T.P. Gogoi for the Central Government. The writ petitioner is before this court with a limited prayer. Petitioner was employed as BSF as
Constable.
Constable GD.
GD, general duty.
Constable GD. Pursuant to a proceeding initiated. There was a proceeding initiated.
My lord.
He was dismissed.
Trial, my lord. GSF, General Security Force Court trial, my lord.
Pursuant to a proceeding under the what is that? General?
GSF, General Security Force Court, my lord. Trial.
General Security
Force Court trial.
Court's trial, petitioner was dismissed from service
With 4 years imprisonment.
with 4 years imprisonment. You have suffered that imprisonment.
My lord, I am in Aizawl jail, my lord.
Presently, he is undergoing the punishment imposed by the GSF court. So, against the order passed by the GSF
37/2023.
on 30
37/2023.
2023. Petitioner has filed an appeal before the Deputy Inspector General, DSF. The Deputy Inspector General within brackets CLO. Then next line FHQ. What is that? Force Headquarters.
My lord.
Force Headquarters, BSF, Fort Central, the address, page number 36. It is the submission of the counsel for the petitioner. Appeal is a statutory appeal filed by the petitioner under section 117 of the Border Security Force Act 1998. So, it is submitted that the said appeal is made pending and no orders have been passed as on date. So, he further submits that by a subsequent before filing the appeal, he had also filed a representation dated 9/9/2024 to the same authority, requesting for certain documents so that he may file the appeal, so that these may be relied upon by the petitioner while filing the appeal. So, this representation has also remained pending and the documents have not been furnished to the petitioner as per the submission of the counsel. So, nevertheless, the petitioner preferred the statutory appeal and the same presenting pending with the appellate court. Counsel for the petitioner submits that his appeal, a direction be issued that the appeal be disposed of and the order that may have been passed by the appellate authority, a copy thereof be served on the petitioner. And further, the documents he is sought for by way of his representation dated 9/9/2024 should also be furnished. Counsel for the respondent does not object to the prayer made. So, accordingly, the writ petition stands closed, directing the appellate authority, namely the Deputy Inspector General, Force Headquarters, he is not here, respondent here.
My lord,
Respondent number who's also the chief law officer, namely the respondent number 4, who dispose of the appeal, statutory appeal filed by the petitioner, and by a speaking order, and thereafter serve a copy thereof on the writ petition. So, if the appeal has been disposed of in the meantime, then copy of the said order be also furnished of the writ petition. So, the prayer made by the petitioner by his representation dated 9/9/2024, seeking the documents, may also be granted, may also be considered, and if these documents are, if these documents can be furnished to the petitioner, the same should be furnished without further delay. So, the writ petition therefore allowed the extent indicated above and disposed of. The directions of this court be carried out within a period of 8 weeks.
it will go long, my lord. Maybe, my lord, 3-4 weeks, my lord.
4 weeks from the date of receipt of a certified copy. date petition, the court will withstand disposed of.
High level.
Pleadings are complete.
Yeah, we have filed affidavit, my lord.
It is submitted at the bar that the pleadings in the matter are complete. Then we issue rule.
It is a matter relating to termination, my lord. It's terminated in 2022. A date may be fixed on a hearing day, my lord.
Alright,
certificate.
then
Regarding
the
caste
matter be
certificate.
listed for admitted hearing in the month of May. 6th of May.
Yes, ma'am.
6th of
In the meantime, the records, if any, may also be called for, my lord. No, we have already filed affidavit denying the caste certificate.
We'll see
Yes,
if the records are required, we'll call for it.
Yes.
6th of May.
6th of
Obliged.
Yes, Mr.
Compliance is there.
Huh?
Compliance is there. I would have to challenge the further proceedings if necessary. The compliance.
Heard Mr. R. Mazumdar and Mr. Deka.
For SS Royal Lord.
Mr. Mazumdar for petitioner and Mr. Deka appearing on behalf of Mr. S. Roy.
For as per number 2.
For respondent number 2. This contempt petition is filed alleging willful disobedience in the direction of the order dated 15/12/2023, passed in WBC 4700 of 2019. So, this by the said order, the writ petition was disposed of. Holding that the petitioner was entitled for a proper review by a medical board, and the respondents were directed to constitute a fresh appeal medical board / review medical board within a period of 2 months from the date of receipt of the certified copy of this order for the purpose of examining the medical fitness of the petition. The counsel for the petitioner submits that since this order was not carried out within the period prescribed, the contempt petition has been filed. Today, when the matter is brought up, I am hearing on behalf of Mr. S. Roy, DC, has placed before the court a communique which reveals that in terms of the directions contained in the order dated so and so, passed in WPC so and so, the review medical board was constituted, and thereafter the petitioner was re-examined and was again found to be unfit.
If Lordship only records one part of it, otherwise closing it,
yes,
that the board was required to contain a specialist, which has not been done. That is only my submission, because earlier orders were there for a specialist. Otherwise, on the closing of the concept, I may do that.
Under such circumstances, Mr. Deka submits that the directions contained in the order dated to comply with, and the contempt petition can be closed. Whereas Mr. Mazumdar, on the other hand, while accepting the submission of the counsel for the petition that has been complied with, that the review medical board has been constituted and the petitioner was re-examined. He, however, submits that from the documents which he has been permitted to
take a copy,
permitted, which he has been also furnished with a copy, reveals that although the medical board or review medical board was reconstituted, the petitioner was examined, but it does not reflect the name of the specialist. Be it as it may, since the directions of this court There is no specific direction.
Page 9 if lordship have.
No, there's the penultimate direction.
There's a history to this case, that is why I'm saying, Lord, the entire order was given because the specialist was not there.
No, no. What I'm saying is that the penultimate direction is that you constitute within so and so.
But that was the direction because the earlier board did not have a specialist. At page 9 lordship. That is how it came to this order.
Then you have to say that the order has not been complied.
That is, I'll have to bring it up in a repetition because they'll try to say that we got some other opinion or something. That will, or if the
he
lordship allows me to
submits-
respond,
he
yes,
submits that he need to- uh, he submits that the direction of the court required a specialist to be a part of the review medical board. That has not been done. A careful perusal of the order reflects that the penultimate direction of the court is the direction of the court in the order dated so into past is for reconstitution of a fresh or fresh appeal medical board or review medical board within the period prescribed. And that having been done, this contempt petition at this stage can be closed as the directions have been complied with. Stop. However, if the petitioner is still agreed with the decision of the review medical board or the constitution thereof, he is at liberty to take necessary steps before appropriate ruling. Terms of the above, copy of the instruction